Welcome to Women Winning Divorce. I am your host, Heather Quick. I'm an attorney, entrepreneur, author, and founder of Florida Women's Law Group, the only divorce firm for women by women. I love thinking big, thinking outside the box, creating creative solutions for women, and empowering women to win in all aspects of their life. In each episode of this show, I will discuss how to navigate the divorce process, come out stronger and empowered on the other side. Welcome to Women Winning Divorce. Each week, we discuss issues including divorce, custody, alimony, paternity, narcissism, mediation, and other family law issues to provide insight on the journey of women winning divorce. I'm Heather Quick, owner and attorney of Florida Women's Law Group. Today, it is my pleasure to have Kat George with us. She is an attorney here at Florida Women's Law Group, and I am so happy to have her on the show. And as you get to hear her and her perspective on things, you will understand why we are so happy to have her here today. Welcome, Kat.
Thank you for having me, Heather.
Absolutely. Now, Kat is a passionate advocate with experience in family law here in Florida. So, Kat, before we get started, I'd like to let our audience know a little bit more about you and what brought you to family law, and most importantly, what keeps you practicing family law?
So family law and I have an interesting relationship. I always say that family law chose me. Initially, when I went to law school, or even before I went to law school, as soon as I graduated, I worked at an immigration firm in Miami, Florida. So the entire time I said I was going to do immigration law. Graduated, came back hoping to do immigration law. Nothing bit with regard to immigration law, but family law bit me. So I've been in family law ever since. And with me being in family law, I appreciate it more and more because you see the evolution of the woman before you. They generally come into you like very despondent, depressed, unhappy about the situation. And then with us working together and even giving them different tools, they come out a totally different person. So it's not necessarily the legal work that gives me the hurrah. It's the fact that I see this woman evolve from who she was to what she is now.
I so appreciate that, Kat, because I've heard you say that before. And even in some of our team meetings that, our clients can't really see it as clearly as we can, right? Because they're in it and we can see this change that is quite satisfying and quite inspiring to watch these women go through this, right?
Exactly.
And also, just for our audience to know, because of course here at Florida Women's Law Group, we represent women only, but you didn't start out that way, but you decided to, hey, this is the right way, right? This is.
I agree, because, when you know better, you do better. And so now that I know and I can do better, I understand that representing women is more so my passion than representing anyone else.
Oh, love you. So you guys, don't you love her? I tell you what. But it's true. And Kat has really, in the couple years that she has been with the firm, I've seen that evolve because I see her passion with our clients and the way you care, because that's what makes us so different, I think, in many ways, because we really do care and we really get excited for our clients when we watch them grow.
Exactly. And then you get upset when an opposing counsel tries to take advantage of them. So that all goes hand in hand.
It does. And therefore that gives us that passion and that, energy to keep going because we believe so much in our clients,
exactly,
and what is possible for them. So today we are talking about preparing for trial, which to non-lawyers might sound boring, but to us, of course, we could talk for days about this, I'm sure, to much of people's, disappointment. However, for us, it's so important to be prepared for trial. Would you agree?
Absolutely. And I think trial is not only important for them to be prepared, but also for their voice to be heard as well.
And that's a big thing that, as we know, doesn't happen as often as I think our clients believe it will happen. Correct?
Exactly.
As far as,
correct.
Talking to the judge and being heard. And I think for all human beings, when you have something to say and you believe that you want to be heard, it becomes really important, even in this venue where it's not necessarily designed
exactly
for our clients just to have a free reign and tell them what they think, right?
Right.
I mean, I've mentioned this several times on the show, and it's just because it is the reality is when we're watching TV, and watching the legal shows. And I do that. I love it. I watch Law and Order all the time. And I've seen everything for the past like 30 something years. But, I mean, that's the criminal law. It's not the divorce case. However, they can commit the crime, investigate the crime, and then go to court and finish a trial within 60 minutes. And it just sets unrealistic expectations, right?
Absolutely.
And that's with commercial breaks, right? So I
Absolutely.
think it's fair for the general public out there to be like, well, what do you mean a year? Like we should wrap this up really quickly.
Exactly.
And there's always an exciting outburst in a trial that doesn't really happen in our day-to-day trials, right?
Absolutely. It's a totally different experience. And what we're getting on television is basically a microwave version of what's actually going on in real life.
And a more exciting, dramatic version. Otherwise, we wouldn't watch it, right?
True. I wouldn't say that family law is not without its dramatics, but it's a different level. And it's a more so personal level, which is why we feel so attached more so to family law and opposed to what we see on television with the criminal aspect.
I completely agree with you. And, one of the things, and I want to, even before we get into, preparing for trial, I think particularly in where we are in Florida, Northeast Florida, but in Florida, how a family law trial even works, because it's nothing like TV. We're not in a courtroom with the jury, right?
Exactly. No, we're not. We're essentially just in a hearing room before the judge.
Which is very unnerving. And I will tell you, because I, started in criminal law, and I'll tell you, it's a big deal, like what table you get, because the right side, which I was a prosecutor, is always closer to the jury. And, we're not like looking at opposing counsel, we're on opposite sides, right? Good and evil.
Correct.
And, right. And so in family law, same thing, I'm like, I figure I'm on the good side, and the evil side, not really, but a little bit. But it's hard. The very first time I went into those hearing rooms, we're all at the same table.
Exactly.
And that can be something that I know our clients don't expect, because we're looking not only at the other attorney, but harder for our clients, they got to look at their husband the whole time.
And that's part of the trial preparation. You let them even know that. And so even with COVID, things converted over to Zoom. And so that was also a difficult thing as well, because just because you're not in the same space, you don't necessarily want to be eye to eye with the person on the other side. So that is part of the trial preparation, because it is unnerving, but we work together hand in hand to be able to at least accomplish what we want to accomplish.
Yes. And part of that is, as I've, matured over these many years of doing family law, trying to make it, I get it, with there's the judge, the judge doesn't wear a robe, the judicial robe. I mean, they're dressed in a suit, but there's an almost, and I think it's a false sense of informality in this hearing room, because we're not in the big courtroom with a witness stand and the judge in the room.
Correct.
But yet it is, we still have to follow all the formalities of the court and, evidentiary procedure as well as civil procedure.
Right. And just something even as simple as presentation. When you're coming to the courtroom, even though it's a hearing room, you're going to be dressed differently to give that sort of reverence to the court, even though it's not the traditional thing that you would see on television.
Yes. And I will say, though, it does vary, because there are some judges here, not in formality or dress. No, we always want to, look our best, of course, and be, dressed professionally. But some of our courtrooms here in different counties, they are in a courtroom, and actually, I prefer that. I think that it lends itself to all participants really stepping it up a level when you have to go to a witness stand. And I like to stand when I speak. And so when you're in more of a traditional courtroom, you can stand up and speak. So I think
that's a very good point, because you can take into account the area, be able to maneuver around as well. So that is a good point with regard to the hearing rooms. You're not standing at all. You're sitting the entire time.
And that can be a long day or 2 days or a whole week. I can tell you, you're like, I wish I could just like walk around and talk. But, so I think like number one, when we're talking about preparing for trial, that's the first thing we got to talk to our client about, because we know based on where they are, hey, this is the setting you're going to walk into and
Correct.
how we prepare them for that, right?
Yes.
And, when we talk about the first steps to preparing for trial, one, we want our clients to understand, hey, this is what you're looking at as far as the day, 2 days, no matter how much time we have together, but we need your input, because our clients know their spouse, their children much better than we do. And we really have to have that involvement so that we're able to accomplish their goals. Wouldn't you agree?
Absolutely.
And, when we're wanting that, Kat, what are some of the things that you talk to your clients about when hey, we're going to trial, we didn't resolve this case? Like, what are some of the things? Because I know they're anxious.
Definitely. And so with regard to trial, details are extremely important. So one of the first questions I like to ask is, what's the worst thing that he could possibly say about you? And then we can just get that out the way, because then if we know what's the worst thing that we can say about you, then we won't be blindsided later on with regard to, evidence or a topic that we weren't prepared for. So we like to deal with the worst first. And then from there, we get additional information from them with regard to, like you said, their spouse, the kids, all those small nuances that I'm not going to know that's particular to your family. Then from there, once I get that information from you, the next step is getting some financial documents from the client.
Yes. And, of course, we've done that way earlier in the case, but we're always needing, updated information.
Correct. Right, because
And
like you were saying beforehand, a trial can take a year. So the documents that we had in the beginning of your case might be stale in comparison to the documents that we need at trial. So we need some updated documents for that.
yes. Now, witnesses, because I know you've heard me say this, I'm going to court to win, right? Therefore, we need to know what we got to have in order to win, which usually includes witnesses.
People think you need like an expert witness. Your neighbor can be your witness. Your sister can be your witness. So your witnesses can encompass several different types of aspects with regard to your own personal life. And that just jumps back to what we were saying, like we need as much information with regard to your spouse and your children and those other individuals who also have that relationship. And then you'll be able to provide that to us.
Exactly. And that's why, if you are in this situation, your attorney has to know these things. And we will tell you, okay, you gave me a list of 5 names, which to me, that's better than no names. And then we have to, bring it down. Well, what are our issues? Because that's, I think, big part of trial preparation and knowing it's identifying these are the issues that we need this court to decide. All right, well, what evidence, meaning is it a witness? Is it documentation that the court needs to decide in our favor on this issue?
Exactly.
And right. And so that's why it might be the neighbor, it might be the family member. And what I always like to say first to our client is, well, what do you think they're going to say? And because we all, I'm guilty of it always, this is what I heard that person say, but we need to talk to them because we're certainly not calling witnesses that we haven't spoken with, right?
Exactly.
Because we don't want them to harm you. Because even though you think they might say something one way, we have to interview them and we really need to hear from them what their recollection is. And then we can, as your attorney, determine, I think this will help. I don't think it'll hurt, right? Because that's even the worst. It might help, but we really don't want anybody on there who's going to hurt you.
Absolutely. And that's part of the trial prep. So not only us getting the updated documentation and meeting with the witnesses, we need to actually prep and hear what the witnesses have to say, because if they're going to say something that's adversarial to us, or maybe not even slightly beneficial, we want to use that time more efficiently.
And we will talk about time later in the show for sure, because that's one thing I know that really shocks many people. And we talked about it at the beginning, a little bit of timing, with me making the joke about TV and that hour long. However, the amount of time that we do get is something we got to talk about, because you have to be efficient with that time. for sure. So we will definitely touch on that. And something else I want to talk about, and we'll touch on a little bit after the break, is, those text messages, emails, and my favorite, voicemails. Hopefully not
Beautiful.
from our client, but definitely from someone else, right?
Right.
This can be very powerful if they're helpful on an issue. So we'll be right back after the break with Kat George and can continue talking about trial preparation. Thank you so much. In the first part of the show, we started to talk about trial prep and really address a lot of essentials, which is the client participation, witnesses, and gathering the documents that we may use for evidence and we may need for evidence. And part of that, this is something that, Kat, I'd love for you to explain, because I know it's always difficult, I think, for our clients to really understand about, the deadlines the judge sets for
Correct.
when you can have this evidence, like we started to talk about, the text, the emails, the voicemails.
Exactly.
Explain to our listeners, like, what this means, these deadlines, and why they're so important.
Well, the deadlines are important so that both parties are put on notice with regard to what the other side is providing. So at the pretrial conference, the judge is going to set a deadline for all of us to provide our discovery. And our discovery is going to include those updated documents we talked about, the text messages, the voicemails, and the emails. And then with us then providing those documents, they're even going to give us a deadline with regard to what witnesses that we want to be able to testify at the hearing. So the pretrial order, it gives us essentially a deadline for all of us to put not only the other side, but the court on notice of what documents we'll have and how the trial will proceed forward.
Yes. And, as somebody who at heart at times, I'm a procrastinator, right? And
aren't we all sometimes?
and I think that this is because I get it and I understand where people are coming from, because as they look at more information and they know it's coming up, right? We know the deadline is there, the real trial can't really turn off the brain on, oh, what if this happened? This happened. Let me search this. And so now we get inundated as the attorneys with a lot of information, and we're getting very close to the deadline. And that makes it more difficult for us as your attorney to make sure we have the right information by the deadlines, because we have to review it all, right? And determine, is this relevant? Is there a downside to submitting this? Because maybe it's only one half of a text or email exchange, and
exactly,
they bring the other one. But I know our clients, as it gets closer and closer, they just start remembering and they're trying to pull everything together because they recognize that the trial's a big deal.
It is a big deal. And so that's why, at least with our firm, which I appreciate, we don't wait until like a month or so before the documents are due. As soon as we get the order from the judge, we're already working collaboratively together to get all those documents, because you're right, memory fades. Like, you remember something Tuesday and then you forgot about it Thursday. So with us collecting everything, then we have time to review it, because once that deadline hits, nothing else is admissible. We can't just say, hey, I forgot about this. It's done.
Right. And that, I know, can be so upsetting for many clients, because they're like, well, what about this? And what about this? And I know that we spend a lot of time and we ask very specific questions about issues. And do you have any evidence? Because, we may, we're not going to know, do you have a video, voicemail, text, or email? But we're going to say, do you have anything that is going to help us? And you got to give us enough time, because the judge, may not let it come in if you're bringing it on the day of trial. You're probably going to be allowed to bring that in.
Exactly.
And particularly in a divorce case, because, and this relates because the majority of individuals before ever, going through a divorce, their only understanding of trial and cases like that is from TV and movies. I mean, it just is, and in criminal cases, are just different. There's more at stake, frankly, under the Constitution, because it's due process and your liberty. So sometimes if you'll watch on those shows, they let a lot of stuff happen. But remember, it is TV versus the divorce, and everybody should know everything ahead of time, document wise. And our laws require us to exchange it all. So there isn't that ambush, right?
Right. Not that gotcha moment that, we're hoping to see, that you see on television. We've already provided it to the other attorneys. We've already provided it to the court with regard to what documents that we need. But, like I said beforehand, we don't start waiting until a month before trial. Frankly, as soon as you walk into the door, we're essentially preparing for trial if we're not able to come to an agreement at mediation. So some documents you might have given it to us, or some video recordings or text messages you might have given to us when you walked in day one. And then as part of our preparation, we're already compiling those. And then we're asking you what additional things you have for us.
Right. And that's why it's important, is because I know many times you can tell me if you've had this experience where our clients feel like, well, they haven't provided this documentation. Why do we have to do it? And frankly, it's because we're going to follow the rules of evidence and law and what the court said in order to get that advanced. And if they're not going to follow the rules, we're going to argue that their stuff shouldn't be brought in, right?
Absolutely. We would object to them bringing in that documentation, but the better prepared we are, the better we'll be able to represent you. So our representation isn't based on what the other side does or does not do. Our representation is based on our relationship, which is why then we want to make sure we're as prepared as possible, probably to the point you might be annoyed and say, Kat, please stop asking for more documentation. I'm going to say, well, we need to win this. I'm going to ask you for it. And I'm okay if you're mad at me at this, but then 6 months down the line, you're going to be like, oh, maybe I was a little too hard on Kat. Thank you, Kat. And that's really what I want. That's that whole evolution that I enjoy with regard to family law.
And, I think that that's such a good point, because the more prepared you are, the less bumps in the road you have, but then it just goes so much smoother, and you're just so much more prepared to present the case. And part of that is, something, we don't always have a deposition in every case prior to trial, but we do give our clients, a script, right? Of like, hey, this is, so that they understand where we're going with the questions, right?
Right.
And what that does, I learned that many, many years ago, because when I was doing, and some of my family law trials have been very big trials, but the more witnesses you have, I would have files for the witnesses, and I'd have, their 5 to 10 pages of questions. But then, I know if they're out of order or whatever, like we're ready, but then it also allows the client to understand the flow, right? Because we don't want our client at trial being like, oh, I don't know, I don't remember that, right? They need to know what's coming as far as questions.
Right. And then when we get to trial, we're at trial, like that's the end of it. So the beauty of depositions, it's another discovery mechanism. And so you don't ever want to ask a question you're not prepared for the answer. So depositions allow you to ask the question, know what the answer will be. So when you get to trial, you understand where the conversation is going. So that's one of our ways to prepare, so that we're not essentially at trial being blindsided. And I always like to use this slogan, like, you don't have to get ready if you stay ready. And so depositions, discovery, all these other things, that's us staying ready and not waiting to the last minute to get ready.
Mm. And that's so true. And then we can also anticipate more, obviously, the other arguments on the other side, and where maybe our obstacles will be. And hey, this is going to be the issue. We can tell our clients, this is going to be an issue that the judge is going to have competing evidence on. And so exactly. That's why this is so important. And that's why, to your point, like, I keep asking you for more information, because we're wanting to be, solid on whatever this point may be. And also, with the deposition, sometimes we do that. Well, we always do it with experts, because it's so very important to get that information from them. But it's also almost like a way for them to get ready for what it will be like during a trial, which is a lot of questions that are to the point and telling the story, right? It's best to be chronological, to draw it out so that the court clearly can understand what you're trying to say, because our client can't just go in there and just talk.
Right. Because we have to be efficient with our time.
We do. Let's talk about that timing, because, you learn this over the years, and, how, when you're in a trial, and even if they give you the whole day, all right, if you're lucky, you're starting at 9 a.m., there's going to be breaks and a lunch, and they're going to be done at 5. Some judges, back in the day would let us stay and would carry on till after dark, but that doesn't happen as often. But I think what they're, I try to explain to clients, we have 4 hours. The first hour is everybody saying hello, introducing themselves. And before you know it, the time just flies by, right?
Exactly. And so that's one of the aspects of the pretrial order. The pretrial order is going to tell us how long the trial is. It's going to be a full day. Is it going to be 2 days? And then even then with us exchanging the discovery, part of the benefit of us doing that in advance is that we can agree, we're going to agree to introduce this discovery. We're not going to agree to introduce this. So then we're more efficient with our time. But you'd be surprised how much 4 hours goes by, because realistically, it's 4 hours for me and 2 hours for me, and 2 hours for the other side. So that goes by pretty quickly. And so that's another aspect of why we want to have a good flow and chronological order so that we're using our time efficiently during trial.
Yes, because, right, when we say there's a day, but half of that is for our presentation. And it's such a timing thing. And it really is important to get what you need in front of the judge to be heard within that time, because, our time is so valuable. And I've been, certainly, earlier in my career, we'd be like, we'll get it done quicker. And courts would be mad because they're like, okay, you have 3 witnesses. There's absolutely no way this entire hearing will get done in 4 hours.
Right.
Which I know is mind-boggling to most people. They're like, 4 hours is a long time. But, in court,
not at all.
There's objections and then argument. I mean, sometimes it can just go on forever, it seems.
Yes.
And we're not really moving forward. And that's why it's just so important to understand. That's why we spend so much time with you as the client and helping you understand the pros and cons to maybe things that you want to say to the court. But what we're trying to tell you is that won't really advance your issue. And yes, there's the judges, I think, in family law understand to some extent that people want to be heard, but they're not going to put up with a lot of nonsense.
Absolutely. And, just to be frank, it's going to be hard to get 20 years down in 2 days. It's going to get hard to get 10 years down within 2-day trial. And so we still want your voice to be heard, but we also want to give you our expertise with regard to how your voice will best be heard. Some other things might not help progress your case forward or progress our point forward, but something else will. So it's unfortunate, but at the same time, it is fortunate because then the court's not there for weeks on end. We're able to deal with this within 2 days, within a day, but efficiently still be able to progress your case forward or finalize the matter and still give you the opportunity to have your voice heard.
Yes. And it's just a balance. It's a balance of so many variables, and time being one of them, and, enough opportunity for the evidence to be heard and for both sides. It's so often that the judge will say, all right, we got 6 hours here. How long are you taking?
Right.
All right, are you giving, I've been in front of some hearing officers and judges who are really keeping a tight clock, and they're like, you've already used an hour. Now that means they get an hour of your time to finish questioning. And so it's really a management of time, evidence. It takes so much to really make sure we're maximizing our time so that the court hears what they need to hear and our evidence gets entered.
Yes.
And one thing, just as, I don't know if people think about this or not, but how important it is to have a court reporter.
Yes, because the beauty of a court reporter is our memory fades, but the court reporter will essentially type up everything that's said during the hearing, even a sneeze. They'll type up everything so that if we ever need to go back on something, because at the end of the day, sometimes judges make errors. We want to be able to look back on that transcript to say, oh, this is where the error occurred, or even just to point out something, we have that transcript. So basically for all my hearings, even a 15-minute hearing, I'd have a court reporter there just so that we can preserve the record if anything else in the future occurs.
Yes, and that sometimes not everybody really understands that, but it's important because that's the only way to truly record what has happened.
Exactly.
All right, so we're going to take our next break. And when we come back, let's talk about all the do's and don'ts for clients actually during the trial. All right, Kat?
Yes.
All right, well, we are back for our last segment, and we are still talking about trial preparation with Kat George, an attorney at Florida Women's Law Group. And we're getting to our favorite part of trial preparation, and that is, hey, how do you need to act during trial? Because again, that doesn't come naturally, and we take it all very seriously, and we go through a lot here at, not go through a lot, but we make sure you're very well aware of what to do and what not to do, right, Kat?
Yes, yes.
And the biggest thing that I think is helpful for everybody to remember is that you do need to make a good impression, because first impressions matter.
Yes.
And our judges are human beings, right?
Absolutely.
So they're going to observe all kind of stuff, right? Everything, which, let's start with your appearance.
Yes. First and foremost, it's still a courtroom, even though we might be in a hearing room. So you still dress professionally. You'll wear a suit, male or female, and just present yourself in a way that you let the court know that not only do you understand where you are, that it's serious, but you also respect the courtroom. So jeans and a ball cap, absolutely not.
Yeah, and that just makes, again, it's having respect for the proceeding. You don't have to like your spouse. You can have your own opinions of the court to yourself, but you need to be there and understand that it's a serious matter. And what I know I've said before, but like, you know, this person, we are in front of this judge and they can put you in jail. Like, you got to take people seriously, right?
Yes. That's one thing about the television shows that's true.
Yes, it's true. And even the lawyers, right? I mean,
right.
If it got out of hand, I mean, they have that power. And when you're entering a situation where somebody has that much power over you, you need to take it seriously.
I agree. And then the sensitivity of the matter is, no matter what, with a divorce, we're separating an institution, or we're going to be sharing children. And so the situation is already sensitive enough that we just want to make sure we're respecting the entire process and really putting our best foot forward. Indeed.
And you know, with that, let's talk about emotions. Because, you know, it's hard in anything that affects your life, your children, your money, you know, it can be emotional, and that you just need to understand that and be very aware, because whether it's extreme sadness or extreme anger, that's not going to bode well for you.
No. And I can go to, I don't know, Cuba, Jamaica, wherever, and not be able to speak the language, but I'll be able to communicate via body language. So I just say the importance of body language is 10, because even if you're verbally not saying anything, the judge can see if you're rolling your eyes. The judge can see if you're shrugging your shoulders, or the judge can see if like you're kind of squinting to the side of your eyes, just upset. So granted, I do believe you're entitled to that emotion, because if someone is saying something about me that I don't feel is true, of course I'd be offended. Absolutely so. But with regard to the case and the fact that we have a strategy, we prepared for this, and we have a goal at the end of all of this, we want to make sure that we control our nonverbal communication, because no matter what, that's still a form of communication to the judge.
Exactly. And you don't want, I guarantee you, to anyone listening, you don't want to be the one in that courtroom when the judge says, "Excuse me,
oh my gosh,
ma'am or sir, stop rolling your eyes. I'm watching you and you need to cut it out." You know, that's just mortifying. And as adults going through life, you're not used to being somewhere where someone will tell you what to do and you better listen, right? And we don't really want our clients to be in that position.
Right. And it just hurt the morale if you feel like you've been admonished by the judge. And I definitely don't want that to happen to any one of my clients. So that's why, you know, as part of our trial prep, us meeting, preparing, and even just discussing all those things. And even sometimes with me, they'll say, oh, I can't believe he's saying that. How, rude, and have a look. And I'm like, well, you can talk to me about that. Absolutely. You can even have that look with me. Absolutely. But when we're before the judge, absolutely not.
That's right. And because, and I'll tell you, in a situation where children are involved, this stuff is 10 times more important.
Exactly.
If it's just money, I mean, the judge is going to make a decision on money, and they're not going to be as concerned if you don't like the other person. Or they really aren't.
Right.
It's clear. But man, when you're sharing minor children, man, these judges pick up on this stuff, and it'll hurt you. It does. It just hurts you because they don't think there's enough respect, and you're not going to really maybe do the things the judge is going to order in communicating with the kids. And I've just seen it gone, in terrible ways. It can.
Right. Because for the court, it's always what's in the best interest of the children. And if we have parents who can't even work at co-parenting before the judge, they're going to assume when I'm not around, can you imagine the way they'll co-parent now? And so that's why it's also important in those nonverbal cues and communications, just go beyond just a courtroom. It can also affect the order that comes about from the hearing.
Absolutely. And so, okay, we're in the trial. I'm going to talk about a couple things because we all have, stories. So one thing is, you better silence your phone or just don't bring it. And especially if you're not tech savvy. And I'll tell you, for everybody out there listening, the judges are a lot nicer and softer than they used to be. And that's not because I'm old. I started practicing at a very young age. However, it's just different. And that I'm sure is good. I don't know. But I had a client and this is before iPhones. Okay. I'm pretty sure this is before iPhones. So that is dating myself, but it was difficult for her to turn off and it wouldn't stop. And I swear that judge was about to take her into custody.
Oh my.
He had a very short fuse. And, so if you don't know how to work it, please don't bring it. And that's a big deal. And this hasn't ever happened to me, but I've heard judges talking about it, where somebody is texting during the trial.
Oh my. That's
bad. That's so bad, isn't it? I mean, the court's just they're gonna see it. Like, I think that's where it's like, don't act like a teenager, because teenagers think we're not gonna know anything. Like, they know what's going on, right?
Right.
And they're just you're going to lose so much credibility if you do that, right? And so then now there was no need to do that. And the judge had you both coming in on an even playing field, and you do stuff like roll your eyes, texting somebody or not your phone. All of a sudden, their opinion of you is going to change. I don't think it's going to change the application of the law at all. However, if there's a reason, like if maybe they don't trust you as much now when you say something.
Not saying that they're going to be biased because of that one aspect, but if there are other things that were said during trial, that could just be the icing on the cake. So we definitely don't want any sort of texting, because even frankly, like we spoke about earlier, a hearing a trial could take all day, 2 days. So there are going to be breaks. So even between those breaks, we shouldn't be texting because it's still a confidential proceeding. So that can also affect us in other aspects. So absolutely no cellular devices.
Yes. And, this leads into the telling the truth. Oh my God. Yes, we are telling the truth in there. And if there's something that you're really afraid of telling the truth about in trial, you ought to tell your attorney way before trial, so that maybe we can settle it and avoid a situation where you are under oath. But the court, they're very good at reading people. And typically sometimes there is, your spouse knows a lot about you, right? Just like you do about me. Lying never ends well. Like, it's never a good idea. I feel like they're gonna figure it out, and it's better to be upfront and maybe explain why something occurred than trying to lie and cover it up.
Absolutely. Candor, truthfulness, that's all very, 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 very important to the court. And if the court sees that you're not truthful, that can essentially go towards their ruling. And they'll essentially include it, like this person lacked candor, was not forthright. So we never want that to occur. So that's why, from step one, when we're preparing for trial, we say, what's the worst thing that he can say about you? And so once we know that, we're prepared for it. And if it does come up, we're going to be forthright with regard to it. We might have done some rehabilitation since that occurrence, since that event transpired. And then so we can let the court, yes, we did this, but we've done this to rectify it. So no matter what, we want to be as truthful as possible.
Yes, it's just, you can't say it enough. It's so important because they're just going to know. And it's not worth it under any circumstances. And same with your attorney, for anybody listening, like you put us in a really bad spot if I know you've lied, because we have obligations to the bar, to the court, and to you as a client. And it's never, ever worth it. It's just never worth it, because then your attorney has some obligations as far as what we have to do.
Right.
If we're well aware you're lying. And now I want to go to this because I think it does have to go to telling the truth and taking breaks. If you're in the middle of your testimony, we can't tell you what to say, right? Like we can say, you're doing a good job, just follow it, but like there's a lot of gray area and things could be misinterpreted. So it's really important that you understand and listen to your attorney when we're like, we can't talk about this right now. Take a breath, take a break and go back and remember what we told you.
Right.
So one of the things because we've all had things that happen, but which we'll tell, because I think that they're helpful for individuals to understand. But one of the things that I have always done for our clients is bring a pad of paper and a pen. And I was like, and I don't need you writing furiously. I just need you to occupy yourself. Because again, the way with which you do everything is being observed. But, what I think that all clients, and what you need to understand is when you're in a trial, we are your attorney, and we are doing so many things at one time that you're nudging our arm to tell us something is not okay.
Right.
Now, also sticky notes. I do give sticky notes as a paper so you can write those, because then the court will let you have a little bit of a break to talk. But, we've got to not only ask questions, but we have to listen, because that changes the way our next question is going to be. And so we're asking, listening, thinking of maybe an argument or something else to do. But then also if we have to respond spontaneously to a legal argument. So there's a lot going on that you're like, don't forget to ask them this. It's just not a good idea, right?
No, and I agree. And I give a notepad as well, because there might be some points that someone said that we hadn't prepared for, that we didn't know, because we can't always anticipate what the other side is going to say. So they might bring a point and write it down on a notepad. I think that's okay. But constantly writing every single point, I can't be alert to what your husband is saying, how he's responding, and how I then want to go back and question him thereafter. So a note that's to something pertinent, yes, but to every single thing with regard to what's going on that might not be as important, but might just be like frustrating to you. Like, I can't believe he's saying that. That's not something we want to divert our attention from, because we want to be alert to be able to respond if there's anything that's objectionable or that we want to follow up and question on.
Right. And again, that just goes to preparation. So, for our clients, like, we've rehearsed, like, we understand, we've done this hundreds of times. It can be very stressful to you as that person, but if you can, and that's why it's so important to have such a good relationship with your attorney and trust them and know we've got this. And hey, I'm going to ask for a moment where you can share that with me. And if you'll, just be patient on that, because we know what we need to get in front of the court. And
yes.
We also, of course, know how much time we've left. And then most importantly, right, when to stop, because when you're ahead. And you're like, good.
Exactly. I agree. I mean, I had one hearing. Talking.
You got to
right. I had one hearing. My client started talking, and I had to kind of nudge her. I was like, "Ma'am, we're winning. We don't need to interject. Let the court admonish him. We don't need to say anything else."
Mm-hmm. And yeah, sometimes that's the most important time, when you're done,
right?
When you need to stop, because the court's made their decision. They know they've heard enough. And that's where it's like, let your attorney be your representative.
Right.
Because we understand this world that you don't, because we're lawyers, and we also know how to get the best outcome for you.
But letting us be your representative, like, you don't need to interrupt. You don't need to interrupt your spouse. Definitely don't ever interrupt the judge. Sometimes you want to interrupt opposing counsel. 9 times out of 10, I want to interrupt opposing counsel, but I will not. I'll let them get their point across, because no matter what, the court is going to give us an opportunity to respond.
And they are. And I have been, believe it or not, admonished for interrupting. And you get carried away. So it's hard. It's hard to go into court and be like, oh man, it's like back in school,
Oh my gosh.
tell you when to stop talking. And it's tough for me, for sure. But, so we understand, but that's why you gotta let us do it. But lastly, Kat, because this is so fun and we could keep talking for hours, I'm certain. But before you go, could you please let our listeners know, what have you learned about divorce and representing women throughout your career that you'd like to share?
I've said this before, and I'll say this again. Divorce is a death, and you have to properly grieve and mourn the death. So even though you might be happy or sad to embark upon this, it's still a natural emotion, so that it's okay to feel sad. And I'd rather you cry in front of me than not. I don't need you to be like, I am woman, hear me roar. I just need you to be your natural self. And so with that being said, like, we're grieving it, and that's part of the evolution of it. And so when you come to me, it's okay to feel sad, even though you're making this decision. And it's okay to be happy 2 days later, even though you're making this decision. So it's all part of the evolution. And with all that being said, with us growing and evolving, divorce is not you saying, I'm giving up. Divorce is you saying, I'm standing up for myself, and I'm just embarking on a new chapter in my life. And the fact that you have the opportunity to embark on a new chapter, I think it's amazing. Sometimes a woman will say to me, well, I'm 50, I'm 60. And I say, on God's green, beautiful earth, you'll live for another 40, 50 years. Enjoy the 40, 50 years. Don't use that time to be sad. Enjoy it, embark upon it, go through the evolution of it. And then when you're on the other side, you won't even recognize yourself. So I'm even going to say this, I actually stole this from Heather, but I'll share it with you. Journal. Literally journal the day that you thought about getting a divorce. Journal the day that you meet with your attorney for the consultation. Journal the day that you've actually retained. And once you journal and you chronologize those feelings, then you'll come back and you're able to actually even look back on and say, wow, look how much I've changed with regard to that. So that's actually Heather's idea, but that's one of the things I've learned about practicing. So I thought I'd share it.
Kat, thank you so much. And I will say, if you're looking for a guided divorce journal, let us know. We have them in the office.
Absolutely.
Mail them to you, or you can come pick one up. Kat, it has been a pleasure. I thank you so much for sharing your experience and wisdom with our listeners today.
Thank you for having me. I'm excited.
Thank you.
Thank you for joining me for this episode of Women Winning Divorce. If you or someone you know is looking for answers regarding divorce, reach out to us at FloridaWomen'sLawGroup.com, and also join the conversation on social at Women Winning Divorce. Women Winning Divorce is the place for an elevated conversation on how women can thrive during times of adversity in order to live their best life.